Philip Dube. All right, Philip, in reference to the new trial against former officers Lane, Kyung, Tao, Miss Elise asked, I guess it's Mrs. Elise, asked, don't they have a right to a speedy trial? All right, I'll let you answer that, Philip. Of course, they have a right to a speedy trial, but of course, a lot of issues going on in the world, COVID and some other things. What would you say to Mrs. Elise?
Yes, every defendant has the right, a constitutional right to a speedy trial. It's guaranteed in the Sixth Amendment to the United States Constitution. Additionally, there are statutory rights under state law, and I'm sure that Minnesota is in accord. However, every right is subject to a good cause exception, delay, and if counsel or even the defendant personally needs more time to prepare, then so be it. We file papers and try to get more time to prepare, especially in a case of this magnitude. You know, we're not talking about a petty theft or a joyride. This is a very, very serious life-altering homicide offense, and I would hope that everybody is ready rather than rushed to trial.
Now, regarding the delay in the Floyd case, the judge, sua sponte, decided to get a delay. He wanted to put a little bit more time between the Chauvin case and the three officers case, and there weren't any objections on both sides. Just want to get your thoughts if you think that was a good idea.
If I recall, and I'm not 100% sure, but the short answer is yes, it was the right decision, because remember, we were still in the throes of the pandemic, and I think they severed the defendants for separate trials to limit the head count in the courtroom and make sure it was safe and healthy. By having too many people, too many witnesses, spectators, etc., it could turn the trial into a super spreader event.
Yeah, but actually yesterday, the judge on his own, he had set an August date. That date has now been moved to March of 2022, and he did that on his own. And I did speak incorrectly, though. The prosecution, they did object, saying they were ready for trial, but then agreed ultimately to that extension.
If I'm not mistaken, I think there are several motions still pending by the defense. And they're not going to be able to properly litigate those in time, get responses or whatever discovery or additional evidence that they need after the judge rules on those motions. So, you know, time was not on their side at the moment, and they obviously need that to prepare.
No question. All right, let's move on to our next question. In regards to the defense motion to indefinitely delay Durst's trial, Lorraine Byrne asked, apparently he's not even being treated for cancer, so why the delay? When will we know the judge's ruling? All right, now, as far as when we know the judge's ruling, on Monday, things will get going and we'll find out how he wants to handle it. And I know the defense is asking for a hearing. So do you suspect that they'll get a hearing on the issue regarding whether to delay it because of his health issues?
Oh, first of all, the judge that's overseeing this trial is very fair. He's a very, very smart man. He's not going to just make a shoot from the hip ruling from the bench. He's obviously going to give both sides the opportunity to be heard. And if it requires having to put a doctor on, he'll hear from the doctor. But just on its face, just on the law, there is very well established case authority in California that basically says a physical ailment, short of being unconscious, or actually in the hospital, is really not grounds to stop a trial. Remember, you cannot
Philip, I'm sorry, buddy. I'm going to have to cut you off because we're coming up to the end of the show. But I think you answered the question clearly. I don't think he's going to go for it. We'll see how he handles it. Thanks to you, Philip Dube. You truly appreciate it. Thanks for being with us. Vinny Politan is up next, and we'll get you caught up on all the day's legal news.